Yes, my lord, I am paying for listing of the matter, my lord. I long back, my lord. By tomorrow, my lord.
Tomorrow. What is the agency?
My lord, it's a habeas corpus, my lord.
But Mr. Sikdar, in these matters, please give advance copy to the home. Otherwise, there will some delay
Right.
in getting order.
Right.
Extra copies, please give them. Because they normally complain that
Right.
copies were not received by them in their cards.
My lord, item number 11 and 12 may be adjourned for today.
Please say loudly.
Item number 11 and 12 may be adjourned for today.
11, 12.
Due to some personal difficulties of my children.
Okay. Adjournment slips are given in item
Yes.
number 3,
Yes.
7,
Yes.
11, 12, 15, 16, and 17. See, both sides are represented. The pair make by the chart. Let's start with 2 minutes. Okay. All these are at job. Wherever slips are given.
That you're praying for listing the machines
Just give it to the
for motion.
Adjournment matters are item 3, 7, 11, 12, 15, 16, 17.
Daily list for hearing, item 1.
Lordship, this matter may be adjourned. Lordship,
This we were heard earlier.
yes, Lordship, but some issues are going on, Lordship. Let it come after 2 weeks, Lordship.
Okay, this falls in the same category.
Maybe, Lordship. That is why, Lordship.
Just find out that.
Okay. You will just inform Mr. Dev what is happening.
Oh.
You just,
If possible, Lordship, can it be after 4 weeks, Lordship?
okay, but tell Mr. Dev you could not know.
Item 2.
To adjourn the matter? Okay. Both sides are represented on a joint prayer made by the learned counsel for the petitioner as well as the learned standing counsel for the FT matters. List on 15/9/2025.
Okay.
But Ms. Verma, I had gone through everything, including the judgment in 6A, in the 6A. We don't find that it is legally permissible. So far as judicial order is concerned, the administrative orders are different. We make no comment on that. But so far as judicial orders are concerned, maybe that's impermissible.
Working on that.
It's okay. I'm just telling you that the judgment of 6A is. Yes.
For references pending that cannot be available. That's amendment. We have a price from the Department of. Yes, not.
There's a very young visitor in the courtroom.
Lordship.
No, please keep it there. It's okay. But she's a young visitor and we have nothing to entertain her. No, it's okay. Be there, be there. I'm not worried about that. But we are sorry that we are unable to entertain her. Okay. Yes, item 2.
Item 2.
Right. Let's call for Mr. B. Islam. After some time, we'll wait for the counsel.
Item 4.
It is your lordship. Lordship's a contested matter. Influence order is at page number 71. Dated 8/11/2019, lordship. Lordship, in this case, the petitioner,
In this case, the school certificate,
lordship,
the school certificate exhibit 1,
lordship,
the principal, present principal had come, not the author. Uh, Because if that document goes, how do you connect yourself to your projected parents? And this DW3,
lordship.
in his evidence at cross-examination, page 74,
Yes,
he says that the counterfeit of the certificate was issued without mentioning the date of duties countersigned by. Although we don't agree with the finding that it's a forged document, but still it's not been proved. Again, this exhibit 5, that was rejected because it is not readable. I don't know how this evidence was led.
Daubura certificate and that Daubura was examined, Lordship, and
You have a readable copy still with you?
Lordship,
You have a readable copy of that document with you? Exhibit 5?
exhibit 5, Lordship, sale deed. All the- Oh, I don't know. Thank you.
Exhibit 5. We are more interested in exhibit 5.
Lordship.
Exhibit 5 is a sale deed.
Sale deed.
This was rejected because it is not readable.
Have to check. Can you see the visible? Sale deed, yeah.
This is exhibit 1. Exhibit 1, we may
This
not take a,
Not ethnicity, it's only for the purpose of NRC.
no, whatever be, but even the, what do you call, first we'll examine the contents, then come to that part, whether it is only for, because if a link can be established otherwise. No, that's okay. Disclaimer is only after appreciating the document, then disclaimer. So if there is anything to connect her with the projected parents, we're trying to find out that. Please pass it on. This is your exhibit 5. This document. This is exhibit 5. Just.
It's front page or Lordship.
No, but can you read it? We have the original one. You see, we don't need a photocopy to read it, but this is a document. Tribunal rejected it because it's not readable. Hmm.
It's Power and PW4, page 68. Wrap. Brother. Mm. Written statement, Lordship, page 50, Lordship.
in your written statement, you are not making a connect with the land of 1947 with the entries made in the Jamadi of next at page 39. Readings are not there. Have you said anything in your evidence on affidavit? Because something is not matching in your written statement. It makes us very, very difficult to accept. See, come to page 50. First of all, you say that your father purchased a land in 1947. Correct. Then please come to, that is a paragraph 6.
Hmm.
Now, 7. Opposite party father was reading in Samaguri High School. He passed class 7 in class 1987. So, if your father purchased land in 47 and 87, 40 years, we will not accept a proposition that at the age of 40, somebody would be in class 7. Even if your father purchased land when he was 0 years old, then also he would be 47 in the class 7. We are not expecting that. Somewhere you are wrong. And you are just lucky because my esteemed brother has read the handwritten one. You made a wrong translation, and you
Definitely, it's also in English.
para 7 at page 53. You just added word and it made a undone everything. But then the school certificate goes exhibit 5. It's miserably failed to do it because the evidence is that Wagner was applied in the name of some other student, and then it was given it to you.
Like page 62, her own brother came and deposited TW2, page 62, Lordship.
But the document must be proved first. Oral evidence will not be a substitute to a documentary evidence.
Kaubura certificate, Lordship.
That is oral evidence. Kaupura certificate, that is also a defect. Because if other documents don't match, then a Kaupura certificate would not be a proof of a citizenship. It would be a document to support it and to show that there is a shifting. But that would not substitute to be a proof of citizenship.
Lordship, exhibit 7, page 33, 34. Copy of appointment order of the Anganwadi worker, Lordship, kindly see.
Pardon me, exhibit number?
Exhibit 7, page 33, 34, Lordship.
Exhibit 7.
Lordship. Page 33, 34.
Just a moment. So this is 89 document, post 71. Exhibit 7 is the office order of Social Welfare Department appointing you as Anganwadi worker. We are trying to find out because you have shown us a document of 1947. We just wanted to connect you with that. Though we can't read that, but we assume that you are right. You see, the essential pleading is not there. Once you say that your father had purchased a land in 1947, description of the land is not given, so therefore a readable document, which is the Jamabandi, we can't connect it. At page 39, where is the your father's name?
Page 41.
Lordship, page 40,
Page 40,
Lordship, page 40,
serial number
serial number eight- 18, Lordship.
18.
18. Asen Ali.
And where is the mutation order of serial number 18?
Lordship. Pita Manik. Father Manik. Manik is grandfather. Lordship, serial number 18, Hasan Ali.
No, serial number 18, what is the corresponding entry in the remark column? हमने क्या जाना है डेफिनेटली আপনি জানিব কিন্তু জাস্ট আপনি রিমাইন্ড করি
Lordship, page 41. Page
page 41
41,
is
Lordship.
an entry of substitution of the deceased with legal heirs.
Legal year.
So how did the first name of your father came in the Chanavandi? That is what we are examining. Your father purchased a land in 1947. His name must have been mutated. There would be some order of mutation. We are not getting that. So if you can help us to find out that entry, at least we can connect you with your projected father, there is a document of 1947. Right.
Lordship, kindly see Exhibit 6, page 25, sale deed of petitioner Lordship. Page 25, 26, vernacular 26.
The land which is there at the first sale deed of 1947 has got nothing to do with this sale deed at page 25. They are two separate sale deeds of different plots of land. This is not connected, anyhow connected. This document you gave us is not connected with the land at 1947. This is a land which you say you had purchased in 1997. And you don't say that you have purchased your father's land. You say that you have inherited your father's land. Oh, sorry, that also you have not pleaded in your written statement. That is why we are making that, examining it. We are examining it only so to find out, because you have projected a document of 1947. So it would not be, you would not like to throw that document just without examining it. That's why we are examining it and trying to find out if you have been able to connect. The problem of this document is that the reference itself was made in the year 1997 as a doubtful voter. So any document which is post 97, we have to examine that in a different way, being a post reference document. So the pre-reference document, we are trying to examine and find out whether you have been able to connect yourself to the person in whose name the 1947 sale deed is.
Lordship, only the matter may be remanded back and examined.
No, remand can't happen. If you can understand, then we can remand. If you don't understand, then you know the fate. That sale deed which is available there in the record, please see.
Lordship will send back.
Oh, acha, you have sent it back. Okay, okay. Okay. তো তাহলে এর যদি মাটির দাগ নাম্বার পাতা নাম্বার পাই যাবে পেতে হয়ে যায়।
Copy আছে না? Copy না। Copy আছে। আচ্ছা, ঠিক আছে। না, এটা 15 minutes পর না। চাপতে না করে। চাপতে না। এই যে daily লিখতে থাকে। এগুলো তো না নেই। নিজে কনফিউজ হয়ে যাচ্ছে। Then,
We'll take it up day after tomorrow. You'll be prepared because this is the, we have told you why we are not finding any connect. Today, there's a young visitor. We don't want to disappoint you. Take back your document.
Item 5.
Lordship, item number 10, Lordship, kindly adjourn.
Says
the
it present
matter
on
for
the
the
pair
day,
made by land council for the petitioner. This stop. Yeah, tomorrow.
Lordship, item number 10, Lordship, kindly adjourn the matter for the day.
10.
Item number 10, Lordship.
Okay, 2 weeks. Okay.
Oblige, Lordship.
Item number, make to take the matter after tomorrow. Day after tomorrow.
No. Hmm?
Day after tomorrow.
No, no, no. You should have sent an advance notice. We would have understood. The earlier council has a small child to take care of, so therefore we adjourn.
One of the drinking order, my lord, you will find me that case. It is even as a 16 my lord. Drinking order, my lord. 17/6.
In this case, we find that your father and grandfather, they are disconnected.
My lord. There is shifting, my lord. Initially, my lord, they were president, my lord, of village, my lord, Sampopara. Thereafter, my lord, shifted to
Fathers, please repeat again.
my lord, our grandfathers, my lord.
Is in 1966.
My lord, this, my lord, 17, my lord,
That is
next one.
Kampu Para.
My lord, this is Sampo Para, my lord. Abdul Chauhan, my lord.
No,
That, my lord, her grandfather died
Yes.
in the year, my lord, 1957.
as per your written statement, when did your father die?
My father was prisoner, my lord.
Hmm?
His father was prisoner alive, my lord.
Father was alive.
My lord. Grandfather, my lord, died in the year 1967.
Did your father come and give evidence in your
My-
favor?
Yes.
Where is that?
Lord, fifth, my lord. Our father, my lord, was here. Tahir Ali, father, my lord. Fifth, my lord, 61. The next year, 15 million. Tahir Ali.
You bring us to a very difficult situation. Because if your father was born, he is 63 years. Then he will be born sometime in 1956. Where is your 1977 voter list of your father?
Yes, please.
Is it at page 25?
25 years, this is 1970. Very good, let's look at page 21. Seven, that's 19 years, kindly. And answer two.
It's okay. We're just trying to find out. He was 55 years in 1997. He's not there with your grandfather. As per your written statement, when did the shifting take place?
First shifting मतलब took place in मतलब
Paragraph 5, you say it due to family separation. In the year 1968, there's a correction, whether it's 68 or 66, we can't read.
not
Paragraph 5 at page 42. Is it 66 or 68?
the first shifting was in 68 मतलब
68.
हाँ
Then why your father was not there with your grandfather?
that is for explain मतलब grandfather died मतलब in the
This paragraph 5
मतलब
at page 43, oh, sorry, 42.
first one
Now, what do you mean by this? He shifted to Noapara in district of so-and-so in the year 1968, wherein the opposite party was born. So was the opposite party, the petitioner was born in 66? Or you want to say that she was born in Noapara? And what is your, according to written statement, what is the year of your birth?
not as per no written statement was he was born मतलब in Noapara
But when were you born?
after 68 shifting was in 1968 मतलब therefore she was born.
According to you, when was the petitioner born? Because this arithmetic doesn't match. Though I am weak in arithmetic, this
Yep.
in the during calculation the arithmetic doesn't match.
No, first shifting was मतलब in 1968
Hmm? 19?
68 first shifting मतलब father was shifted from मतलब Sampura to मतलब Noapara After first shifting, he was born at North.
No, no. Since you are very vague, we are asking you, what is the year of your birth? Because the documents are not matching. You are not able to find out your date of birth. Whichever document we are taking up and calculating, your age of birth doesn't match. Even your father's age doesn't match.
There is some discrepancy in the age. Then
You see, he came and gave his evidence where he had sworn an oath and given his made an affidavit. As per that affidavit, he was 63 years old in 2019, which makes his year of birth in 1956. So if your father was born in the year 1956, 68, you were born is out of question.
Voters list, his name appears for the first time in 1977 at the age of 45 years.
That's why that was the third part we were coming to.
We also trying to calculate.
It doesn't match.
32.
No document is matching.
Okay, prior to 1977, he has to.
Then if we accept that, the second part would be that if he's born in 1956, as per the evidence, in the evidence he says his actual age is 63. Then he was born in 1956. So at the age of 12 years in 1968, there was a partition and he left home. At 12 years of age, your father could understand all the nitty-gritties of the world, take a decision of partition and leave the parental home at 12 years of age.
the death of father.
We don't know. If your father died, then he could not have come and give evidence in 2019.
Father, that means he could be his
Grandfather.
grandfather.
No, that's why you see a 12-year age
Hmm.
child, he can understand the family disputes and can take a decision of partition. For a moment, we are not saying it is not possible. We were just awestruck that a boy of 12 would have so much of decision-making capacity.
Not his mother also went to him. As per mother,
That's not your pleaded case here. Mother must have left, but it is the young boy who will lead. Because the paragraph 6 this says, due to family separation, he shifted. He takes his mother with him, that is another thing. Have you pleaded anyway when you were married? Year of marriage, is it given?
That is, it's not मतलब credit मतलब,
Pardon me?
that is not credit मतलब.
There's not pleaded. Is there any voter list of you and your wife together?
Yeah.
Oh, sorry, husband together?
അത് मतलब,
Because in page 47, oh, sorry, no, not 47, it will be page 2 of your written statement. You say your marriage was in 1995, paragraph 6. No, not this document.
Paragraph 18 shows his lordship.
No,
deferred
just a
to
moment.
the
Pardon me?
Page 46.
In the written statement, paragraph 6, he says that no, where did I read it?
Page 42.
He was born in married in 1995. I just read it. In 1995, you say is the date of marriage.
W, he has just mentioned that her name appears with her husband in 1977.
Which page?
Page 48, paragraph 18, lordship.
48.
That the opposite party begs to say that her marriage was criminalized with Jamaluddin. In the
You're
year
reading
of
which paragraph? 48? Which paragraph? Which paragraph?
Paragraph 18 says she was married in 1995.
Ah, yes, that's it.
Yes,
Paragraph 18.
yes, lordship.
Ah, yes, 1995. Thank you. I read it but missed it. 1995, you were married.
And her name appeared in 97
97 for the first time.
I think
for the first time, but she has been shown as a revoter.
we are trying to look into it. It's very difficult. Now your who's your daughter? Daughter's name is the voter list of 1997. Please come to that document. 1977 voter list is at page 25. What is the name of your daughter?
It's not there, lordship.
No, we don't know. You see, page 65,
Yes,
he says, my name is recorded in voter list of so-and-so and my daughter's name is recorded. This is evidence of Tahir Ali. Oh, acha, I'm sorry. I'm father. This is father.
Father.
Okay.
his son's names are there, even I checked that.
But then, where is your name in this 77 voters? Just we saw that. My daughter's name is recorded in the voters list of 1997. 1997.
Her husband, looked
With her husband.
with her husband, not with the body. That is paragraph 18 of the WS.
नहीं मिले तो क्या होता? कितने नहीं मिले? नहीं, सिग्नेचर पूरा पर है. हाँ? नहीं. Anything more you want to say?
No,
Is there any other document to show proximity of your age? As a proof of age, we can accept any document?
not accept voter list, my lord, we are not allowed.
Which one?
Accept voter list, my lord, that is also not 35%.
Okay. Do you have any school certificate here? No.
Gabra certificate, my lord, have annexed to Gabra certificate.
Pardon me?
Gabra certificate has been annexed.
Which page?
Now the- Because it doesn't come in details now.
He did not comment reports.
Only father and.
But where is the document? Let us see that.
My lord, page, my lord, 34, my lord,
Page 34.
my lord, next page.
Here it doesn't give the age. We just wanted to verify the age.
Page is not, my lord. Another document, my lord, next year, my lord, next year, my lord, 11, my lord, that is, my lord, page, my lord, 36, ration card, my lord. Here, my lord, the entry, the very entry in the ration card, my lord, Ambia Khatun, father's name, my lord, Tahir Ali, mother's name, Zulina Khatun, and husband's name, Jamaluddin, my lord. Page 36. My lord.
Yes, 36 years.
Still one
Amia
nine, my lord.
Khatun, F32.
36, my lord. Ambia Khatun is,
But this is of which, which is the date of printout? No, but this page 36 is an exhibited document, no?
my lord, yes, not okay.
But this page 36, why you are showing us this report? Report is otherwise also a secondary evidence. Why you did not show us the original one? This is a report. Report means a secondary evidence. It's not a primary evidence at all. Then the date of printout is not there. Because as per this document, your name is Ambia Khatun. You were 32 years old. Computerization took place only in these few years. If you are 32, and this computerization, let us say, it takes place about 5 years back. That brings you to a different age group altogether. Your age of birth will be different now. Computerization took place when? 5 years, 6 years?
It's not an exhibited document.
No, it's okay. But
Yes.
now, even if we accept this, let us say that this computerization took place of the ration card 5, 6 years back.
It is post the opinion.
No, that's okay. But here her age is 32 years. Serial number 000128, Ambia Khatun,
My lord.
32 years. 32 years, let us say this is in, even if we take it at 2020,
21, she filed the case.
it's okay. Let us say this document is of 2020.
3 years.
This is 2020, let us say, then 32 years and his age is 43 years. It doesn't match. Yeah. Huh?
What firstly, I would like to rely on the written statement filed by the petitioner lordship. And I would like to rely on this document, on this citation lordship. This is reported in GLR lordship 2017 4 GLR 295. It's a short paragraph, may I read it lordship?
Please give the citation again.
2017 4 GLR 295.
Name of the parties.
Saru Sheikh, SARU,
SARU.
SARU,
F
S, S,
S
yes,
ARU.
yes, Saru Sheikh, SHEIKH.
Yes. What does it say? Paragraph?
Paragraph 13, Lordship. It is on the written statement. It says, Lordship, having noticed the above background, we may now examine the stand taken by the petitioner before the tribunal in the written statement. It goes without saying that in a proceeding before the foreigners tribunal, written statement is the basic statement of defense of a proceeding. Having regard to the mandate of Section 106 of the Evidence Act and Section 9 of the Foreigners Act, it is incumbent upon a proceeding to disclose all such facts which are specially within his or her knowledge having a material bearing on his claim to be a citizen of India at the first instance itself. That is in the written statement. Such facts are thereafter required to be proved by adducing cogent and reliable evidence. Failure to disclose such material facts may lead to drawing of adverse inference against the proceeding. In the written statement so filed, petitioner did not disclose his date or year of birth. Consequently, there was no disclosure regarding his age. He also did not disclose the place where he was born. Here, the petitioner has disclosed where she was born, but the year and the age is not mentioned, Lordship. The first fact, which we will be looking into the voters list later on, Lordship. Lordship, then I would like to rely on the voters list. Suppose you have disclosed the age, you have disclosed the age anyway. If it is put it there, or put it there. No, but it is. Yes, it is put 43.
Yes,
Lordship, paragraph 14 again comes on the age. Such a written
of
statement
the
is
same judgment.
same
Just,
judgment. Lordship.
just-
Just first 4 lines.
just a moment. Yes,
Paragraph 14, Lordship is found.
yes,
Such a written statement is wholly inadequate to make out a case of citizenship. It is also tried that a party is bound by his own pleadings in the written statement, and he cannot traverse beyond the pleadings. Be that as it may, in his evidence in chief recorded on 31/2016, petitioner disclosed his age for the first time. Here also, Lordship, nowhere has the age been disclosed. Only in the affidavit I could find it. That when it was filed at 43 years, he was 43 years of age. Then Lordship, coming to the voters list, he has failed to show any linkage with a projected parent. Another citation which I am relying on is Aziz Mia, Lordship. WPC 2370 of 2023.
970.
2370 of 2023. Aziz AZIZ MIYA, Aziz Mia. License Mohammed Aziz Mia. Lordship decided on 9/6/2023.
2 23 fortunately 246.
Lordship, paragraph 14. May I read it, Lordship? We are constrained to observe that a mere claim by a suspected person by referring to a voter's list, claiming a person therein to be his father, is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voters list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials accepted in law. And Lordship, last one I'm playing reliance is on Basiran BB, which was reported, Lordship. It was reported in 2018. Two thousand eighteen one GLT 372. Paragraph 30, Lordship. 30. Lordship, here it says the lines placed in the case of Abdul Matali can be of no assistance to the petitioner in as much Lordship, it is fine.
Yes, I will.
2018 1 GLT 372. Paragraph 30, Lordship, reliance placed in the case of Abdul Matali Supra can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decisions that the said decision did not lay down any law and was a decision confined to the facts and circumstances of the case. Regarding discrepancies in the voters list which the petitioner contended are not her creation being entered into by officials of Election Commission and therefore should not be used adversely against the petitioner, such contention is without any substance. The voters list were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portion of the voters list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence would be examined. The document has to be appreciated as a whole. And lastly, Lordship, the writ of certiorari, the Supreme Court judgment, Central Council of Ayurvedic Sciences, 2023, Lordship.
Yes.
The curtain back, Lordship. 2023 SC Online, SC 996. 2023 SC Online, SCC Online Lordship, SC 996. Paragraph 51 onwards, Lordship. 50. 50, 51, 52, that was okay. 54, 50, 51, 52.
Heard Mr. B. Islam, Learned Counsel for the petitioner. Also heard. Honorable.
Item 6.
Six time. Seven page, I said.
Yes.
May I please understand? I am appearing on behalf of A. Devan. The youngest counsel is out of his position due to his mother's illness. So
In
thank
which
you.
item?
Item 6.
6.
Kindly to extend, granted, my lord.
But you should have given an advance. We are not adjourning matters like that. Tuesdays and Thursdays are very difficult days.
My senior will inform tonight. So
What has happened?
my senior is out of his position, so he's informed tonight.
Okay, we'll take it up next week. Next week, there will be no adjournment. What says the representative?
Last chance.
On the prayer made by learned counsel for the petitioner, the matter is adjourned. Today, list on 12/8/2025. So the matter would not be adjourned on this said date. No adjournment on next date. Okay. Item 8.
Item 8.
Please, your lordship, matter may be taken at 2 p.m.
Okay. Item 9.
May I please, your lordships? Opinion is at 72, lordships, page. Okay, in opinion dated to 2/3/2020, page 72.
Page number
Page 72, lordships.
72.
Lordship, after going to the opinion, I find that I exhibited in the instant case, notice was issued. The notice contained my father's domain. They admitted, and the daughter's side. This is their document. A written statement submitted, additional statement with details of my family tree. Everything's are clearly stated. Then evidence, chief, cross, myself, my brother, school headmaster, Gaugura, and school certificates also. provided. Nothing considered in the respect of evidences. Documentary evidence also some statement given, but no considerations at all.
Lordship, may I read this?
Consideration is there, it is not favorable to you.
Lordship,
Consideration is there, may not be favorable to you, but
only
consideration is
interpretation,
there.
so these are the documents. Whether I am the daughter of so and so or it is related to me, nothing I find. Lordship, that's why I read this Lordship will find page 73, exhibits are stated up to exhibit 12. Then Lordship will find page 75, 3 exhibit considered on what are the grounds? Paragraph number 1, 2, 3, 4, 12. Out of the above listed 12 exhibits furnished by DW1, only 3 exhibits bearing exhibits 5. Exhibit 5 is the school certificate. Exhibit 6 is the Gaubura certificate. And exhibit 12, that is, this was the Gaubura certificate, are for establishing office date, year of birth, and for establishing linkage with the projected parent. For the purpose of appreciating the evidence adduced by the OP, the above said 3 exhibits are scrutinized first by laying emphasis on relevancy, authenticity, admissibility, reliability, and proof thereof. Exhibit 5, pleaded in WS shows Piara Begum, date of birth.
Where is your written statement?
Lordship, written statement is at page 37.
37.
37. Details, I have discussed my partner. Everything I have stated in that's the family, everything, even my marriage, everything. Okay. Page 37, paragraph 5, regarding my place of birth, lordship, this thing, quote, I am citizen by birth. Paragraph 5, my family, three grandparents, parents, my siblings, everything, lordship, paragraph 7, father's family, lordship. Then my siblings, paragraph 8.
The Gram Panchayat, the secretary came to give evidence.
Gaugura lordships, page 69.
Gram Panchayat secretary, did he come? No.
Panchayat secretary not lordship. Gaugura. Gaugura certificate, evidence page 69, and Gaugura certificate is page 31, exhibit 12. No finding at all.
Where is Gram Panchayat certificate?
Page 31.
31. Is that Gram Panchayat certificate pleaded in your written statement?
Yes.
Where is that? I missed it then.
Page 42. Yes. Page 44, lordship. Para 12. Para 20.
Oh, this is additional written statement.
Yes. That the government Gaugura of Katamoni has been issued a certificate in the name of the opposite party, and the certificate that Piara Begum, late one resident of Katamoni Pata, Katamoni, Moja, Procedural, district North Austin, said that he knew no hard barrier. And in respect of evidence, my evidence as well as school headmaster evidence, government, not a single word reflected in the evidence. My evidences are also not, there is also not reviewed, nothing, not documents also not also reviewed.
This Gabra certificate is exhibit number?
Exhibit number 12, Worship. Page 31 is the particular, page 32 is the, page 30 is the particular, English discussion, page 31.
Yeah,
Yes,
come to page 33.
33. Panchayat Secretary certificate.
With the seal of and the government of Assam part, this document is inadmissible, correct? Now let us assume for a
Government-
moment that page 33, you have an extra 7.
And extra 7 years.
With this use of the state emblem, this document was inadmissible. Now
State
for a
emblem?
moment, we assume that we will allow you to rely upon this document. You're relying on this document. Do you rely on
Tribunal
this document?
ignored. This document tribunal has already ignored.
No, no.
I am
Would you like to
relying,
rely
mainly
on this?
relying my school certificate,
You are
government
not-
certificate, my evidence, oral evidence.
No, no,
document.
please reply to the question. Our query is, page 33, are you relying or not relying?
Regarding age lordships, you have mentioned 20, but other contents lordships, daughters,
We don't know about that. Our first question is,
You will rely on this.
does the petitioner rely on this or not?
I am
today-
also
today-
relying along with other documents. But since
If
it was not proved, that one point lordship taken note, that it was ignored because the author has not came forward before tribunal to prove it. So ignored it. Government certificate is there, school certificate is there. It has to be proved, but it was not proved. It was not proved.
Mr. Barbia, we are otherwise also very complicated people. Tell us in short reply, yes or no. This petitioner, whether she is, or you as a counsel, are you relying on page 33 or not? Yes or no?
I am lordships since I have annexed the certificate of my father's name, but incidentally, age wrongly recorded in the.
very well.
I am not relying on that document.
Now, if you come to page 15, what was your age as on in 2020?
My date of birth as per school certificate, 1
No,
1985.
you come to your affidavit. Come to your
Affidavit,
affidavit, page 15,
page 50.
the affidavit supporting the writ petition.
Thirty-five years
35
on 2020.
in 2020.
Yes.
So what is your age in the year 1995?
1985, I was born.
You were born.
Born
That you agree
15
to?
years,
That you
20
agree
years.
to that you were born in 1995? That is your
1985,
1985,
85, not 95. Tribunal held that tribunal held exhibit 1, 2, 3, 4, 8, and 10. These are brutal list. Presumes all are correct. Exhibit 1, 2, 3, 4, brutal list contain my parents' name. Held, my parents are Indian citizens. Exhibit 8, 9, 10, it is also brutal list. My name contained along with my husband. Held that since I was born after cut of death, so I am not citizen. They relied upon I am the daughter of so. Their documents I am the daughter of so and so person, and their documents are also genuine. On what ground they are not challenged? These are their documents are not correct. Their inquiry would say. And apart from that, I discharge my burden, oral and document. In the documentary loss, you find only some statement, no considerations at all. And in respect of my evidence, 4 witnesses, nothing, only in respect of brothers, evidence stated that my brothers has not produced any document, but he produced his voter ID. And even also in the voter list contain his name along with the parents. 1985 voter list. And my family, team, my brothers, siblings, everything has been mentioned. They have not challenged nothing else, not attributed even. They have not changed the document evidence. They have not refuted my evidence. They did not came forward to rely upon their case. They have stated to in the inquiry board. They stated 2 witnesses. They got information, but that information that 2 witnesses also not been examined. SPB also not examined. I am relying in this respect of the Honorable Supreme Court judgment, Rahim Ali. So many times I have also produced before your lordship. Your lordship is aware of that in that case also, 24 decided regarding inquiry. Very initiation. And apart that judgment, lordship civil appeal, petition civil diary number 20674 of 2017. Today I have 1 copy, lordship. Earlier 2, 3 copy, I think. But paragraph may be referred, lordship. Paragraph number 23, 24, 25, 26, 28, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 49, 50 and 54. If lordship permit, may I read 49, 50 and 54. Yes. And regarding non-consideration of my evidence, your lordship has said, lordship. And recently, your lordship decided WPC number 8243.
যাতে যাতে জাগা নাই তলত রেফারেন্সটো লিখি দিও এইটো জিএলটিত আছে yes which paragraph
Lordships, WPC 8243 of 2018.
paragraph
Paragraph 456. Short paragraph, may I read? Copy. Paragraph 4, Lordship. On receipt of notice, it was disposed of on 11/11/2024. Lordship judgment. On receipt of notice of appearance, the petitioner submitted a written statement so and so on 7/4/2017 along with 13 documents denying that she is a foreigner and claiming that her parents are late Azmut Ali and late Maharajan, and that she was born in village Wardap under 60 number Kadari Dagapara Gao Panchayat in the district of Nalbari. The petition also projected that name of her parents are enlisted in the brutal list of 1966 and 1970 in village so and so, so and so. In support of her stand, the petitioner had examined 4 witnesses, which so and so, so and so, and so. Next paragraph 5. However, in paragraph 4 of the impeached opinion, the learned tribunal has mentioned that the petitioner has adduced the evidence of 5 witnesses, impugning herself, and exhibited 13 documents. And in paragraph 8 of the impeached opinion, all the 13 documents are referred to. However, in paragraph 10 of the said opinion, under the heading Decision and Reasons thereof, the learned tribunal has briefly discussed only the evidence of DW2 and DW4 and has referred only to the certificate issued by the secretary, number so Kadari Gadabara Gavanchai, Exhibit 1, and also brutal list of 1989, Exhibit 7. Thus, the learned member Foreigners Tribunal number 2, Nalbari has failed to discuss the evidence of DW1, DW3, DW5, and DW6, and the said learned tribunal has also failed to discuss the exhibits 2 to 6 and 8 to 30. Under the circumstances, the court is of the unhesitant view that the learned tribunal has not properly appreciated document and evidence adduced by the petitioner, and as such, the impugned opinion dated so and so is held to be not sustainable on facts and in law. Therefore, the said impugned opinion dated so and so passed the learned member for the tribunal number 2, Nalbari, in application of so and so is hereby set aside and direct the matter to remand back to the said learned tribunal, which will be required to be reappreciate the evidence and give a fresh opinion in accordance with law. Then I relied upon the decisions of this court, Lordship 213-1 GLT, page 941. Abdul Khalik versus Union of India. One copy I have. Motive.
Yes, Abdul Khalik.
Abdul Khalik Lordship. Evidence also not challenged. No. Paragraph 9 and 10. Paragraph 9, the appellant in his deposition in categorical term has stated that his grandfather's name is Abdul Wahab, whose name appears in the brutal list of the year 1965, pertaining to Samaguri Legislative Assembly constituency. The witness numbers 2 and 3, namely Gabura and villagers, Rijibosti village, has proved the said brutal list, which is marked as Exhibit 4. Witness number 3 has also stated that Abdul Wahab is the grandfather of the appellant. Such statements of witnesses have not been challenged by the state by way of cross-examination. Witness number 2, the Gabura of the University, however, has stated that though the name of Abdul Wahab appears in the brutal list of 1965, pertaining to Samaguri Legislative Assembly constituency,
Abdul Khalik.
he, however, does
850.
not know who is Abdul Wahab,
Cross assay.
whether is a grandfather of the
Two
appellant
cross
number
line.
1, witness also having categorically stated that Abdul Wahab is a grandfather.
Hmm.
Such evidence with number 2 would not demolish the case of the appellant as revealed from the evidence adduced by him. More so when there is no cross-examination by any of the witnesses examined. In view above, we are of the opinion that appellant could discharge the burden as imposed by section 9 of Foreigners Act 1946 to prove that he is an Indian national and not foreigner. And the opinion of the tribunal rendered on 9/4/27 in applications and so the judgment order dated passed by the learned single judge, WBCS Championship. Then I also rely upon the decisions of December Court Lordship 2021 GLT, page 330. Motiur Rahman versus Indian Appeal.
Paragraphs.
2021 GLT,
Paragraph.
paragraph Lordships 8, 9, 11 and 12. In this case, 8, paragraph 8, may I read Lordship? In this case, the petitioner has produced the brutal list of 1966 of number 44 West Balpara LSC, wherein the names of his father, Ahmed Ali, and mother, Porijan Bibi, was included. Certified copy of the electoral roll of 1963 is available on record as Exhibit A. The respondents have not disputed the correctness of Exhibit A. The petitioner has also produced certified copy of the electoral rolls of 1989, wherein the name of the petitioner has been entered as son of Ahmed Ali. There is nothing on record to dispute the claim that the petitioner is the son.
Voter list of Exhibit 10.
Lordship. Petitioner has been entered as son Ahmed Ali. There is nothing on record to dispute the claim that the petitioner is the son of Ahmed Ali and Porijan Bibi, who are living in India since prior to 1960. Mr. Payang has also submitted in his usual fairness that respondents are not questioning the genuineness of certified copy of the brutal list for the years 1960 or 1989 produced by the petitioner. But the only dispute in this case is as to whether the name of Ahmed Ali shown in the electoral roll of 1989 is the same person who is the father of the petitioner. The name of the petitioner grandfather Manik Sheikh is also mentioned in the brutal list of 1963 and 1970. Paragraph 9. As mentioned above, the DW2, who is the brother of the petitioner, had categorically deposed that the petitioner is the son of Ahmed Ali and Parijan Bibi. Ahmed Ali, who had cast his vote on the basis of entries made in the brutal list of 1966, the aforesaid testimony has not been assailed during the cross-examination of the witness. The respondents have also failed to lead any evidence in rebuttal. Moreover, in the reference sent to the Foreigners Tribunal, the father's name of the petitioner has been shown as Ahmed Ali. We are therefore unable to accept the contention of Mr. Payong that Ahmed Ali mentioned in Exhibit A is a different person. Then paragraph 11. We also find from the record that the learned tribunal has declared the petitioner as a foreigner based on some minor discrepancies in recording of age. That is also important, Lordship, age. And also for non-mentioning of the date of second marriage of his father or the petitioner. However, such discrepancies, in our opinion, are minor in nature, and hence, even if found correct, would not have any material bearing in the outcome of this petition. Moreover, the decision of the Honorable Supreme Court rendered in the case of Firajul Haq versus the state of Assam and others in connection with criminal appeal number so arising from so, it has been held that minor discrepancies in recording the names, age, address of family members of the proceeding cannot be bound to doubt its fate. Having regard to the peculiar facts and circumstances of this case, we are of the considered opinion that the petitioner has succeeded in establishing linkage with his father, that is late Ahmed Ali, who was eventually living in India prior to the year 96. And there are also sufficient materials to show that the petitioner had continued to reside in India since he was born. We hold that the petitioner has succeeded in the establishing his claim of Indian citizen by leading further evidence. The petitioner therefore practiced the allowed. And in respect of lordship, the award of the Sarbandasan also and the award Fulvens this a Muslim word of lordship commented for this. In the Sarbandasan case, paragraph 50, 40 lordship says, no genuine citizen can be thrown out. Natural justice regarding entitled to all safeguards. And in the lordship regarding Sarbandasan wall, two lordship.
Hmm.
2007 1 SCC. In this case, I have discharged the burden list. Everything details family like that. What has to be stated, what are required to be stated in the written statement, just everything complied. The paragraph 50 lordships.
Yes.
Paragraph 50 lordship. Principles of natural justice and undisputably is required to be complied with before a tribunal passes an order of deposition. The 1962 Act and the orders framed therein contain in bill proceeding, the procedures laid down herein are fair and reasonable. Only because the burden of proof is on the proceeding, the name of by itself would not mean that the proceeding is an ultra bias. The provisions Article 21 of the Constitution of India, Article 21 would not be offended if the procedure is fair and reasonable. In paragraph 55 lordships, then paragraph 58. There cannot, however, be any doubt whatsoever that adequate care should be taken to see that no genuine citizen of India is thrown out of the country. A person who places himself a citizen of India in terms of the Constitution of India or the Citizenship Act is entitled to all safeguards, both substantive and procedural, provided for therein to show that he is a citizen. Let us a person, however, be determined according to statute. The Evidence Act of our country has made provisions as regards burden of proof. Different statute also lay down as to how and what manner burden is to be discharged. Even some penal statute contain provisions that burden of proof shall be on the accused only because burden of proof under certain situation is placed on the accused. The same would not mean that he is deprived of procedural safeguard. Then paragraph 50. 60 paragraph. Having regard to the fact that tribunal in the notice to be sent to a proceeding is required to be set out main down. Eventually, the primary onus in relation thereto could be on the state. However, once the tribunal satisfied itself about the existence of downs, the burden of proof would be upon the proceeding. In 62 lordship, it was stated in Sonal first case that there is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country. In order to establish one's citizenship, normally he may be required to give evidence of his date of birth, place of birth, name of his parents, their place of birth, citizenship. Sometimes place of birth of his grandparents may also be relevant, like under section 6A1D of Citizenship. All these facts will be necessarily within the personal knowledge of the person concerned and not of the authorities of state. After he has given evidence on this point, the state authorities can verify the fact and can then lead evidence in rebuttal if necessary. If the state authority dispute the claim citizenship by a person and assert that he is a foreigner, it will, it will not only be difficult but almost impossible for them to first lead evidence on the aforesaid point. This is in accordance with the underlying policy of Section 106 of the Evidence Act, which says that when an act is especially within the knowledge of any person, the burden of proving fact is upon him. In the Eastern case lawsuits, I discharged the lawsuit. Evidence is given, my brother's school have not started appear but they have not challenged nothing. They have not refuted. There is no evidence. They have made inquiry in respect of, but I also challenged the inquiry and the tribunal also did not contain any grounds. What are the grounds? I am suspecting I am a foreigner. Yes, also I have taken my description. So my humble submission is, since nothing has been considered lost in my evidence, document evidence, all evidence, there is a case of remand for reappreciation of evidence by the tribunal. And my on evidence of my, since it was not considered lost in my one of these the judgment loss of this one of court loss of 2022 Supreme Court Guwahati in the case of Korimali lawsuit regarding oral evidence in the near relative also. But here is a nothing considered.
Yes, paragraph.
In paragraph 12, 13, 14, 15, 16, 17, then 40, 51, 52, 53, and 54 regarding oral evidence of near relative. Paragraph 12, my dear learned counsel for the petitioner submits that the reason for the tribunal not to believe the claim of the petitioner appears to be unreasonable and not based on legal premise. It has been submitted by the learned counsel for the petitioner that the fact that the mother, uncle, and younger brother of the petitioner had testified corroborating each other was sufficient enough to prove the claim of the petitioner. It has been submitted that the evidence of the mother, uncle, and his younger brother have never seriously contested by the state. In fact, as can be seen from the cross-examination, the claims that they are mother, uncle, and brother of the proceeding were never put to question. Though during the cross-examination, certain questions were asked about the relationship, names of the relative, and the shifting of the proceeding from Bermuda to Muscari, Islampur, and thereafter Matia, these have been consistently stated by all the witnesses which are not shaken. It has accordingly been submitted that under the circumstances, there is no reason for not believing the evidence of the mother, uncle, and the brothers. In this regard, learned counsel for the petitioner has referred to the decisions of the Honorable Supreme Court rendered in Shamlal, alias Kuldeep versus Sanjeev Kumar in the 2009 12 STC, as well as the decisions of this court in Muhammad Abdul Khalik versus Union of India, 2013 1 TLP 948. In Shamlal Supra, it has been held by the Honorable Supreme Court that if the relationship between father and the mother and the birth of person during the subsistence of the marriage has been shown, it will be raised the presumption under section 112 the Indian Evidence Act 1872 about the paternity and maternity of the person concerned. In the present case, it has been submitted that the names of the petitioner's parents are Asaduzzaman, father, Godbanesa, mother, and after their marriage, the petitioner was born to death, and the same had not been questioned. Under the circumstances, there will be a presumption in favor of the petitioner that he is the son of apostate persons as provided under section 112 of the Indian Evidence Act. In this regard, Learned Counsel for the petitioner has referred to para 9, 10, 18, and 19 of the Shamlal Sutra, which are as follows. Section 112 of the Indian Evidence Act is based on English law. Section 112 produces rule of English law that it is undesirable to inquire into paternity of child when mother is married, woman and husband, and access to adultery on her part will not justify finding of illegitimacy if husband has had access. Instances more than a century ago in Bhima versus Dulappa, the court aptly observed that Section 112 of the Evidence Act is based on the principle that when a particular relationship, such as marriage, is shown to exist, then its continuance must prima facie be preserved. The fact that a man is living in a notorious adultery, though of course it amounts to very strong evidence, is not itself quite sufficient to repeal this presumption. Then in Lal Horiban Lukuja Bihari ILR case of so. It is the principle of law that Odisha at inconesta non sant lege pres commander. Nothing odious and reasonable will be presumed by law. So the law presumes against vice and immorality. One of the strongest illustrations of the principle is the presumption in favor of the legitimacy of children is a civilized society. But where illegitimacy seems as common as marriage and illegitimacy, the presumption of legitimacy cannot be drawn, and legitimacy or illegitimacy will have to be proved like any other fact of issue. When referring the Kanti Devi versus Pushiram to the 1/5/16, this court held as under Section 12, which raises a conclusive presumption about the paternity of the child born during the substance of a valid marriage. It shall provide an outlet to the party who wants to escape from the rigor of that conclusiveness. The said outlet is if it can be shown that the parties had no access to each other at the time when the child could have been begotten, the presumption could be rebutted. In the impugned judgment of the High Court observed that in the present case, admittedly, the plaintiff and defendant of lawsuit do you have personal 2005 brutal list 2010 brutal list and 2014 2005 2005 I would no knowledge regarding to I did not find regarding to the 5 brutal list. One of the brutal list exhibit 7 2005.
No,
No, there's
it's not also annexed to this writ petition.
2005.
Yes. Because in your written statement at page 44, which you made us read,
Page
the
44.
page 44 of the additional written statement, your name appeared in the voter list of
The name of the everybody
2005.
has been entered in the brutal list of the 5 under Jamuna Move by number so also. So under Dovka Police Station, District Nagaon, Assam, Tiara Begum, wife of Hassan Ahmed.
That appears to be your first
Along-
name
along
first
the
appearing in the
husband.
voters list.
The statement is there lost to be. Verify the record loss. Whether it was an exhibited or not.
The photocopy. Private copy না হয়। Photocopy। আৰু সিহঁতে কল কৰা নাই, কোম্পানী কৰা নাই আৰু কল কৰা নাই। এইটো কম্পেয়াৰ কৰি নহ'ব, তুমি কল কৰি দিম।
Lordship. My lord, in Muslim Mandal case lordship, paragraph 103, specifically stated notice contain main grounds lordship. I have only one conclusion. I read this particular paragraph, paragraph 103 of Muslim Mandal case lordship. Lordship, paragraph 103. Having 103 says, lordship, having regard to the aforesaid discussion, we are of the view that in the absence of any uniform laid down procedure, the following procedure is henceforth required to be adopted in the matter of service of notice by tribunals on the proceeding. The procedure laid down herein below shall be applicable to all proceedings pending before the tribunal where the notices are either yet to be issued or issued but not yet served. Passed down, the procedure shall be served with the notice together with the main grounds on which he is suspected to be a foreigner, as far as practicable, personally whose signature, term impression, as proof of service is to be written. So no ground at all, only notice contain, lordship. Notice contain my father's name. They admitted, I'm the daughter's of son. In their case, I am the daughter. And they also admitted, tribunal held that the Bhutan list 1965 containing my father's name, they are genuine Indian. And my Bhutan list produced regarding 2005 to 2010, 2014, 2018. It has also stated that this is also a genuine copy. My name is. So only ground taken, like since the exhibit 5612, there is some difference of age. On that ground alone, discarded my whole evidence. Only. Tribunal also not denied that I am not the daughter also. State also stated I am the daughter also. But there is no question. Image law said that I am not the daughter also. Since I adduced evidence in all respect, my brothers also, my school certificate also proved, Gaubura, that has nothing been considered, lawsuit, I find in the opinion lawsuit. Lawsuit, this is my humble submission. Lawsuit, my humble submission that may ends of justice lawsuit in there may be returned or set aside, since I have discharged my bar. And 2005 voter list, it was Xerox copy, tribunal ignored it. That's in the records. My name is there, my husband, along with my husband. Yeah.
Hmm? Exhibit 12 is on which page?
Exhibit 12 is lordship page 31,
One.
31, 32.
Paragraph 32.
32 particular.
Hmm.
Yes.
Sharma, irrespective of whatever you submit, this matter has to be remitted back.
No.
The matter has to be remanded back. The tribunal committed a blunder. There are three instances where the written statement was either wrongly read or not read. So whatever be the end result, whether the opinion would be favorable to the state or the respondent, but the pleadings must be considered. There's no consideration of pleadings. Come to page 73. Page 73, serial number E, first appearance of so-and-so, F, written statement on so-and-so. Now, there's no reference to additional written statement. We have sent you the records. Please
Yes.
check 23/9/19 order.
Okay.
23/9/19.
29.
Additional written statement file accepted. Correct. So this document is there. After the written statement, 2 or 3 pages down, it is there. And that document is at page, in this brief, it is page 41. No, yes. Somewhere around there. No, this is written statement. After that,
This is additional written.
no, Mr. Payag is looking at, it's after that.
29.
Ah.
29.
Now, this
29.
document is at page 41. It's not referred here. There's one. Second is that please come to the opinion. At page 76. Exhibit 12, second last paragraph. Exhibit 12 not pleaded about by the opinion written statement. The document is unattended for appreciation. Now come to this page. Written statement is at page, additional written statement, page 41. Come to page 44, paragraph 20. Government Gambura of Kadumani issued certificate. Correct?
Yes.
Now come to next page. That's all. That's good enough. So this is the written statement, not considered. Now, come to page 76 of the opinion. First line. From the date of her leaving the said school and as such, its authority is questionable. Apart from that, in spite of having a clear date of birth, the OPS failed to disclose her date of birth in a written statement. Correct? Now, please come to page 39, which is the first written statement. Para 12,
Yes, doctor.
date of birth is there. Correct?
29.
Now, come to page 43, para 13, date of birth is there. So if pleadings are not considered, then the judgment is, the opinion cannot be sustained. It will be perverse. whether there is, whether there is any emblem, state emblem there or not is secondary.
Yeah.
But pleadings is not correctly considered. It may be worth nothing.
No, but
Yes, yes.
There is nothing to say, my lord. Definitely the pleadings has to be, yeah, considered.
No, it may be worth nothing.
Yes.
It may give, at the end, it may give the same result.
Sure.
But if the pleadings are not considered, it's a
That's-
fundamental error.
Whatever there in record, that has to be considered.
That has to be considered.
Without considering the record, my lord, if opinion is first, definitely it cannot be defended.
You will have to consider its incorrect appreciation of the pleadings.
you'll also put in, remand only to reassess, reconsider the materials available in the record.
In light of the
Present.
pleadings.
Yes,
In light of the pleadings.
on the basis of records available. Heard Mr. F. Borgia, learned counsel for the petitioner. Also heard learned counsel for the respondents. The present petition under Article 226 of the Constitution of India has been prepared by the petitioner, assailing the opinion rendered by the Foreigners Tribunal Nagaon 10 in page 72. That's it. Two, three, 22. Notice in this case was issued on 21/1/2021. When the matter first came up on 21/1/2021, this court proposed to examine the case records at the first instance and as an interim measure had granted and requisitioned the records. Full stop. As an interim measure, the petitioner was granted the privilege of bail as recorded in the order dated 21/1/2021. Upon receipt of records from the concerned tribunal by order dated 1/3/2021, notice was issued and the matter was fixed for admission. The brief facts of the case is that the petitioner that on the basis of a reference made by the SPB Nagaon, Assam, FTD case number 1496 of 2015 was registered and notices were issued to the writ petitioner hearing oblique petition proceeding before the tribunal. Full stop. Responding to the notices, the petitioner appeared, filed her written statement on 11/2/2019 and thereafter filed an additional written statement on 29/3/2019. Written statement, edition from page 41. The acceptance of the additional written statement is reflected in the order sheet of the tribunal in its order dated 29/3/2019. The repetition, the proceeding adduced her evidence as DW1 on 25/4/2019 and she was cross-examined on 17/5/2019. DW2, namely Jalil Ahmed, who projected himself as the brother of the proceedee, filed his evidence on affidavit on 11/6/2019 and he was cross-examined on 26/8/2019. The petitioner the DW3
As per the record, this DW3 and 4, how they are treated? Because in page 65, 64, sorry, 66, the tribunal has not written the DW number. This evidence was recorded on 12/9/2019 of DW, this Srimati Amia Basa Hazarika is 66. Please see in the order sheet, it will be easier for you to find out. Order dated 12/9/2019.
Adjournment 2019 it is ordered. OP present today along with the learned context. OP has produced the concerned school headmaster for proof of Exhibit 5 in this state paper. The position of state school headmaster is recorded and pressed separately to the record.
So the tribunal is not given the number. Then there is another witness recorded on 22/10/19.
On 22/10, my lord.
22/10.
Yes, OP is present today along with learned consent. OP has produced the concerned Gambura.
Okay, no, I just wanted to know whether DW has been mentioned. No, not as DW. No, at page 67, it is not there. Mr. Sharma, page 67 of the brief, it is not there.
Gambura evidence page 70. Page 70, Lordship, page 71.
Deposition of concerned Gambura, but he has not given the, tribunal has not given the DW number.
Oh, yes, yes. Yes, DW number is not there.
Ah,
That he appeared as, appeared on a petition filed by the, OCD that I have given so and so as an exhibit and I
Yes,
would want to call
they-
him,
they have
prove
brought-
that document only.
They
Is there
have
an
brought
affidavit?
here.
that is in the order sheet.
Yes, that is the order sheet. They have brought them, madam.
They have what
Because
is.
there is an order sheet that he had wrote a petition and therefore the person was called for.
তাত নালাগে, তাৰমানে নিজে কল কৰিলে নালাগে। কল কৰিলে তেতিয়া এনেকে নাহে। তেতিয়া চবে কৰি দিয়ে।
Madam, may I read it once again? OP has produced the concerned school headmaster. They have to-
PW process on PPD. PW process লিখুন। PW 3 নয়, PW 2 লিখুন। PW 1 was cross-examined on 1905. PW 2, namely Jalil Ahmed, who had projected himself as the brother, had reduced evidence on 11/6/19, and he was cross-examined on 26/8/2019. The OCD had produced and exhibited the following documents during the proceedings, page 73, A plus A लिखें। The concerned headmistress of the school from where the exhibit
Five.
exhibit 9
Exhibit 5, Lordship, page 16. Exhibit 5 is the school.
exhibit 5
Exhibit 5 is the school.
from which the exhibit 5, namely transfer certificate from the Doboka Girls High School, was produced to prove the authenticity of the certificate, and similarly the Gaobura of Kodomoni Pothar Gaon was produced to prove the authenticity of exhibit 12 by the proceeding. Full stop. Though both the aforesaid two witnesses had presented themselves and given evidence, however, the tribunal did not record them as DW and no DW numbers were given. Having Next paragraph, people. The learned tribunal, after having examined the records available before it, had declared the proceeding to be a foreigner as per section 2A of the Foreigners Act 1946, who illegally entered into the territory of India on or after 25th of March 1971 without any valid document. Good stop. Shri F.U. Bormia, learned counsel for the petitioner, by making references to the records available, has emphasized that several of the exhibits marked by the proceedee in the proceedings were either not taken into account or were ignored because of discrepancies which were actually not fatal to the case of the proceedee. Full stop. He submits that such rejection of evidence had prejudiced the proceedee and therefore he prays that the impugned opinion be interfered with and the matter be remanded back for correct appreciation of the evidence led by the proceedee. Mr. J. Payang, appearing as the standing counsel FT matters, has opposed such prayer and has supported the impugned opinion full stop. He has argued that the rejection of the exhibits and the fault found in the exhibits which were taken into account were in accordance with law, and therefore the impugned opinion does not deserve any interference and the repetition may be dismissed. Next para. We have heard the learned counsel for the parties and we have also perused the records as received from the concerned tribunal. Without going into the merits of the documents which were exhibited and the evidence which was led by the proceedee in support of her claim to be a citizen of India, we have noticed from records that the learned tribunal failed to take into account the additional written statement which was filed by the proceedee and which by order dated 29/3/2019 had also been accepted. The learned tribunal has observed in the impugned order that apart from that in spite of having a clear date of birth as projected in the school certificate within bracket लिखो exhibit 5, comma, the proceedee had failed to disclose her date of birth in her written statement. We have perused the written statement filed on behalf of the proceedee and it is seen that at paragraph 12 of the written statement, the proceedee had very clearly stated that her date of birth is 1/3/1985. The relevant para is extracted below. The same statements have been reiterated in paragraph 13 of the additional written statement filed by the proceedee. We have also noticed
But, one,
Ah.
one,
we have also noticed
one thing will also.
that a
No, because Malati, in fact, just prior to this, there is one line, one statement.
we have also noticed that the learned tribunal has recorded that exhibit 12 is not pleaded by the OP in her written statement and hence this document is unattended for appreciation. Exhibit 12 होगा application. It is at this stage that we must also say that at paragraph 14 of the additional written statement, 14 and 20. Sorry, 14 and 20. At paragraph 20 of the additional written statement, the petitioner has referred to the certificate issued by the government Gaonpura of Kodumani. And therefore, it appears that the additional written statement filed by the proceeding did not receive the attention of the learned tribunal. Next. From the records of the tribunal and our observation herein above, we find that relevant exhibits during the evidence of the proceeding and contentions raised in the written statement did not receive proper and due attention of the learned tribunal below. And in fact, the additional written statement, which was accepted by order dated 29/3/2019, was wholly ignored when the opinion was rendered on 2/3/2020. This, in our opinion, will vitiate the decision-making process followed by the learned tribunal, and therefore we are inclined to interfere with the opinion rendered by the learned tribunal in FTD case number so and so, in exercise of powers under Article 226 of the Constitution of India. Resultantly, the writ petition stands allowed to the extent of setting aside of the opinion dated 22/3/2020, and we remand the matter back to the learned tribunal to render a fresh opinion by taking into consideration all relevant documents and exhibits, all relevant pleadings and exhibits available on record. The The petitioner shall appear before the learned tribunal along with a certified copy of this order within
20 days.
within 20 days
After receipt of LCR lawsuit, that will be required.
within 20 days from the date of receipt of a certified copy of this order, or from today. Within 20 days from today, without requirement of any notice, any further notice, we expect the learned tribunal to expeditiously render its opinion on the basis of materials available on record, preferably within a period of 2 months from the date of appearance of the proceeding. Registry to send back the records. Writ petition is allowed to the extent indicated above. No orders.
Your petitioner shall be remain on bail lawsuit. That since petitioner is on bail lawsuit, that may be direction given to tribunal to allow her to go on bail.
You're already on bail.
Okay.
But only one thing I would like to point out, because your lordship has prior to the your lordship observation that apart from that, in spite of having clear date of birth of OP has failed to disclose the date of
You're
birth
reading
of
page number?
that is in the opinion. Fourth page of the opinion. So there is page 76.
Yes.
Yes. Page 75, there is an observation by the tribunal and exhibit the, why it is not written this, but here it is, he has recorded, madam. Exhibit 5 written in WS, page 75 last paragraph. So Piara become date of birth is mentioned is different as daughter of 20 to 20. That has been recorded. This document. But in the next paragraph, he has
Finding is
recorded that
wrong.
his name is.
No, Mr. Pang. Obviously, you don't want us to make any reference to that, those observation in page 76,
Yes.
that you have passed to class 6, but you have not given
No, I'm not,
the proof of earlier education. If you want observation of this code, we'll be welcoming it.
no, I'm not on that, madam. Only thing is that, madam, in the earlier para, he has recorded this, his date of birth is recorded in WS, madam. But in the next para, he said his date of birth is not recorded.
In case we record it in that line, it will go against, more against the tribunal. He has contradicted himself in the first.
He
on the first-
contradicted himself, madam. That's why I
Yes,
said.
so let us not go back.
That's all. And to DW, in fact, madam, the other two witnesses, though he has not mentioned here as DW2.
No, in
Yes,
fact,
sir.
this is very, you see, this page come to page 75.
Yes, sir.
Pleaded in WS shows Pyara Begum as daughter of Manan. These things are in bracket.
This and this and this.
Date of birth according to admission register is not there in the written statement. Please come to this written statement at page 37. This within bracket,
W is directly written.
this within bracket is not there. It is nowhere there.
Yes.
So he is reading somewhere and copying and pasting it from somewhere else.
No, I'm not saying, madam, that it.
Now we have examined it. We were just waiting for some time. We are giving some opportunity to Mr. Barbunia to make submission. He did not make it. So we, after he completed, then we stopped you.
Those two witnesses in the, but in the opinion, he has described as DW3 and 4.
Whatever worth it is.
Those.
Lordship. I'm so obliged. Record. Yeah, Lordship. It will help with the next case, Lordships.
Item 13.
Wait, wait, wait. So this is for compensation at the death at the hands of the police person. 5 lakh people were paid and then interim. I'm seeking more in that, because of your lordship, can you see page 27? Petitioner's husband, I'm just putting for page 40. Otherwise, the law of compensation is more or less settled now. Procedure is settled. Page 27 to 30, here I'm showing that he is the owner of the different motor vehicles.
Mr. Das, this will require some time. No, not that, because we are otherwise tied up in many issues. We have the Itanagar bench opening ceremony on 9th and 10th. So we have certain administrative works also.
So fix it this.
So we'll fix it after 15th. Take your convenient date. When do you want?
15 minus, 19.
19th. Ms. B.D. Das, former senior counsel, assisted by Ms. R. Decker and counsel for the petitioner, as well as Mr. S.K. Hazarika and government advocate are present. For positive time, the matter could not be taken up today. It's been list on 19, 8/2025. Mr. Das, you have given us this 2 or 3 citations which are there on record.
Yes. Now another judgment is there.
Can you give a short, on the next date, can you give us a short note along with the,
Along with the list of dates I will give, it will not take much. What the matter is more or less settled by.
this you want it back to referring to give it us? These are on custodial earth, I think. Just explain. Don't say that, so I'm present. List this matter before any other bench without one of us, begin bracket. And Mr. Muzumdar.
Obliged.
It'll not, it may not be, perfect. This is also one. This table is, it is opened up, this newspaper.
I'll give a list of dates.
And it's a little. মানে তাহলে কি আছে একটা প্রবলেম হবে তো কোর্টে ভাবিছে উঠি যাব এখানে ঠিক আছে ওটা দেরি হয়ে যায়
Item 14.
My lord, here in this case, basically, my lord, there is variation of name of grandfather in the voter list of, in some of the voter list. In 1966 voter list, that you will find at page 54. Here, grandfather's name is written as Ramzan Ali. Actually, correct name is Ramzan Ali. Ramzan cannot be name of a person. It's a wrong recording. Ramzan Ali at page 54. '70 also, my lord, similarly recorded. My lord, in 79 voter list, lordship will find at page 58. Here, father's name is recorded Bacha. My lord, at page 58. 66 and 70. In both the voter list, grandfather's name is written as Ramjan Ali. But against the father's name, grandfather's name is written as Ramjan. At page 58, my lord, the relevant portion at page 59. That has been continued in the subsequent voter list. My lord, in voter list of 1989, although, my lord, it is vernacular, also available in record, I have seen, my lord. 89 voter list. Grandfather's name and father's name are entered in adjacent house number, my lord. At page 68, vernacular at page 69. My lord. 68, my lord, page 68 in my petition. Vernacular at page 69. That is the voter list of 1989. Here, my lord. Exhibit D is 85 voter list. 85 voter list, my lord. At that is at page 60. See, villages, there is shifting also. Initially, they were in village Hormuza. Subsequently, they have shifted to village Huripur Paraikwa. My lord, for explaining the name discrepancy, my lord, I want to, my lord, refer the voter list of 1989 voter list. The vernacular portion, my lord, also available at page 69. Here, father's name is at serial number 621 and grandfather's name is at serial number 623. Adjacent house number, my lord. Here, grandfather's name is written Ramjan Ali. Father's name is written as Bacha Sheikh. But in the 97 voter list, vernacular I have annexed, my lord, at page 71. Serial number 20, house number 7, Bacha Ali, against father's name Haji Ramjan, mother Dorina Khatun. Then my lord, serial number 22. 22 in cancellation, there is a wrong, my lord. It is serial number 22, house number 8. Father's name written as Haji Ramjan Ali. So, my lord, these two voter list is supporting our explanation of the name discrepancy of grandfather. Grandfather in 66, 70 voter list written as Ramjan Ali. And in the adjacent house, my lord, Ramjan cannot be named person. It's a wrong recording, my lord. It is not a fault of the voters. So for the fault of this wrong writing in the voter list, voter should not suffer. And there has been an attempt of correction also, subsequently written as Ramjan Ali. In 79 voter list, against the father's name, grandfather's name is written Ramjan. In all the other voter list, but 66, 70 voter list, grandfather's name is written as Ramjan. So this is the, my lord, basic points, my lord, which has been taken by the learned tribunal to discard everything and declare him as a foreigner. My lord, written statement, lord will find at page 30. So for the date, my lord, the petitioner, her mother was examined, her mother deposed that father died about 22, 23 years back. That is at page 102. Mother's evidence. My lord. Mother was examined. And Proceeding stated that before her marriage, 3 years before her marriage, father died. The exact, my lord, year is not mentioned. And also we have mother name is Zorina Bibi. Zorina Bibi. Zorina Beva, my lord, somewhere. So some bottle is Zorina Bibi also. Her marriage was registered 5/2/2022. And procedure says that before her marriage, 2-3 years before her marriage, father died. So that, my lord, tell you the statement of mother, my lord. Mother said that 22-23 years back,
Mr. Sikdar,
my lord.
when was the marriage?
And now she was that married,
In the year?
my lord, as the marriage document is also available, my lord. in
The year,
annex.
just the year. When was she married?
It is of 2002.
2002.
Yes, my lord, 9/4/2002. Annexure.
As per the statement of
Mother
evidence
says,
of the mother,
mother says that 22-23 years back, her husband died.
in could you come to
That-
page 44 for one.
My-
Page 44. Para 40. Page 44, para 40.
Father,
This
mother
is
have.
perhaps your evidence. Para 14 says, just below the paragraph ending, annexure 3 is the photocopy of electoral roll of 1997. So here you are talking of 1997. At
Para 40, page 44,
4, paragraph 14,
14 of the
you are
evidence.
talking of the
Name of my father and mother have enrolled in the electoral roll of
1997.
1997.
Then come to the next paragraph. In the meantime, my grandfather and father expired.
My lord,
Now you are talking of 2005.
2005.
But if in 2002, if your mother is saying that the father expired 20 years ago, cannot be between 97 and 2005.
No, father expired, that is after 97. Just before the entry in the, just before the voter list 2025. Apparently, my lord, have consistency, my lord. There is no much variation. Marriage document, my lord, is it is, my lord, marriage document. Marriage document also will find at page 80. Translated portion of vernacular at page 81.
Spelling mistake in the grandparent's name, and only on that basis, my lord, his name is the entire case has been decided. My lord, your lordship may kindly see the page 55, the 50, my lord, the page 55. This is the Khormuza village, my lord. Who are the, my lord, listed Buddha in this list, my lord? There are 5 persons: Tormuz Ali, Farjat Ali, Tukur Ali, Tunaban Nessa, Diljan. Now, your lordship may kindly see 1970 voter list as page 57. It is again Toromjan Ali, my lord, Irzat, Tukur Ali, Diljan Nessa. So, the persons whose name were there in 1966, almost all are there in 1970. Now, when it comes to, my lord, 1979 voter list, page 58, all these are prior to 70, my lord, document of 1971, earlier 2 documents. Now, you'll also make a this page 58. This is the document. This is the document, my lord, where names are different. Not a single voter of 1966, 70 are there. Not a single person, my lord. Not a single person of those 2 voter lists. Batsa, Tarabanu, Zarina Khatun. These were not there. Had there been single person of this person, my lord, 66, 71, 70 voter list, you could accept it, yes. This could be a, my lord, slight difference in the spelling. But there is not a single person. That is what, my lord, Honorable Apex Court in, my lord, the Sirazul Haq case says, my lord, if there is some spelling mistake, there is no issue. If other names are consistent, my lord, that qualification is to be there. The other names are not consistent, not even the voters are there. I'm not going to say what consistent. Not the voter, not a single voters are there in 1970. After, my lord, this 1971 voter list. And it is admitted position, my lord, as your lordship has rightly just read out it, para 14 of the evidence, my lord. Grandfather was there up to 2005. 2005, they have said that in the meantime, after 97, that means in the meantime, grandfather and father died. That means grandfather was there. Where is grandfather's name in this police matter? After 71, nowhere. 59, my lord, as case 59, 61 also. The voter list in 85 voter list also, grandfather is not, name is not there. Other family members, forget about the other family members. Even grandparent, father's name is also not there. Page 63. The voter list of 89. They are also grandfather is missing. Page 64, 97. They are also grandfather is missing as a voter.
My lord, I want to make some replies on it.
I just read out only one line because it is relied by them, but because there it is said that the name spelling mistake or name correct, it may be mistake in voter list sometime, but I am relying on other way, my lord. There in para 3 it is like this, my lord. There is no doubt that a grandfather's name, my lord, this is, my lord, the 2019 583 534. Sirazul Haq. 2019, 550, 550. There are three disclaimers. If I read Malati, I give up the bit. Malati 50. 2019, 550, 534. There is para 3 method. That's why I'm relying this method. There is no doubt that great grandfather's name, Amatullah, appears as Amtullah throughout the document. Amatullah as throughout the document. Equally, there is no doubt about the father's name, which appears as Hakim Ali all through. The only discrepancy found in that in some of the documents, Kefatullah later become Kematullah. However, what is important to note is that his father's name Amatullah continues as Amatullah, and other family members associated continued as such. So considering this, my lord, other aspects were there. Considering this discrepancy were ignored. This discrepancy was ignored. And that's why the Honorable Apex Court allowed this matter. Now, in the case, my lord, in the present case, the entire voters, my lord, whose names were there in the earlier 1966 census, they are not there. Not even the malati. I'm not saying about spelling mistake. The names are not there. And it is admitted position, they have admitted the grandfather was there up to 2005. Why the grandfather's name is not there, along with the father in other voter list? This thing has to. Secondly, my learned senior friend is arguing that these are the voter lists which are created by, which are prepared by the government. So they have no fault on their part. So this may be ignored. But this is their document. And my lord, neither in the WS nor in the evidence they have said, they have stated why the grandfather name is not there along with the petition, my lord, the father. That explanation is not there. My lord, even though the, my lord, the grandfather may, my lord, they may sit somewhere, grandfather may live somewhere. That explanation is not there. Why the grandfather's name, despite of living till 2005, not available in the voter list along with the petitioner's father, the father of the petitioner. That explanation is not there. But they are saying, my learned is arguing that these are the voter list, which are prepared by the government authority. So they have no right, they have, it is the mistake committed by the authority. Well, I admit there may be mistakes on the part of the government. It is always, we argue always that this is argue points of argument. That they have the right to, they have the every opportunity to correct it. That is one thing. Secondly, these are the documents relied by them. When they are relying this document, they have to rely. If they are saying that these documents there is mistake, we don't want to rely, they should not rely. If they rely, the documents cannot be relied only one part, madam. That has to be relied in whole. It cannot be read in a part. That has been settled by this honorable court. If you are relying on the documents, you have to rely. But they are relying the documents, but they are ignoring. They want to ignore the discrepancies they are in the documents, and those parts may not be relied. Which are discrepant, which they are where there is discrepancy, that may not be relied. Which has to be done, madam? Either they have to rely or they have not. They have to ignore it, madam. But the document cannot be relied in part. That is settled, madam. This is, madam, in fact, this honorable court, in case of Basiran BB, madam, 2018 1 GLP 372 months. And 2018 1 GLP 372. Basiran BB, madam. Page 372. First last para, madam. Para number is not here. Earlier there was a judgment. That judgment has been distinguished. Reliance is placed on, as your lord said. First last para. Reliance is placed on case of Abdul Motali alias Motleb can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decision that the state decision did not lay down any law and was decision confined to the facts and circumstances of that case. Regarding discrepancies in voter list, which the petitioner contended were not her creation being entered into by official election commission and therefore should not be used adversely against the petitioner. Such contention is without any substance. The voter list were adduced as evidence by the petitioner herself to prove her case that she was not foreigner but a citizen of India. Petitioner cannot insist that only that portions of the voter list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. So if it's relying, they have to rely fully. If they are not relying, they have to ignore it. So my submission is, my lord, that that much in this aspect. So there is, the tribunal has committed no error. And circularly, my lord, we cannot, circularly is very fixed, my lord. We cannot, my lord, ask the, my lord, authority, my lord, the correctness of the fact which is decided by the tribunal. We have to see whether there is any error apparent and whether, my lord, the tribunal has not given any opportunity to the petitioner, or tribunal has, my lord, not taken the evidence, reliable evidence which the findings of the fact of the signal. So there is no error, my lord. He was given enough opportunity. The natural justice was fully followed. Okay, Patni.
Yes, Mr. Sindar.
My lord,
How to explain?
my lord, I have already shown the voter list of vernacular voter list of 89 and 97. ma'am. Here, my lord, the father and the grandfather are my lord, in a adjacent house number. They are in the same brutal list, my lord, at page 68. The translated person vernacular at page 69. This is also available in record, my lord, page 77, 78 of the record, 89 voter list. Father's name is at serial number 621 Basha Sheikh. Grandfather's name written against him as Ramjan. Then, my lord, 623 Ramjan Ali, the grandfather. Then, my lord, grandmother Tarabanu is also there. My lord, in serial number 628, Harjat Ali. Harjat Ali, Diljan Nessa. These persons are available in the 66 voter list, madam. 66 and 70 voter list. The Taramjan Ali, my lord, at serial number 90 in 66 voter list, at serial number 101, grandfather against his name Junawali, my lord, at page 54, my lord, 69, my lord, serial number, it is vernacular, my lord, in down below, lordship will find 1489. উপরোক্ত হিতান বিলাক যথাক্রমে ক্রমিক নম্বর ঘরের নম্বর ভোটার নাম পিতা মাতা স্বামীর নাম মতানেত্রতা 1489 তারিখ অফিস that means it's a voter list of 1989 and this is also available in the record also in page 70 77 and 78. My lord, the father mother in house number 117 and grandfather, one of the grandmother. She has 3 grandmother. One of the grandmother and grandfather is at house number 18. Then his paternal uncle, Harjat Ali, Diljan, paternal aunt Harjat Diljan Nessa, they are available in house number 19. And same, my lord, persons are also, my lord, available in 66. Sonavan Nessa is second grandmother. Sonavan Nessa expired. Therefore, her name is subsequently not shown. But paternal aunt Diljan Nessa is there. Then Shukural is the is one of the paternal uncle. Harjat Ali is one of the paternal uncle. They are available in the 66 voter list, also in 89 voter list. Similarly, my lord, in 97 voter list also, father and grandfather in adjacent house. It may be because of, my lord, it should be considered, but claim is made based on 66, 70 voter list, and grandfather's name is written against the father's name. My lord, in 79 voter list, my lord, also grandfather's name written against his father's name, but it was it may be my lord, a shortcoming on the part of the proceedings that this 97 and 89 voter list containing the names of grandfather, father are not produced. But it may be considered, my lord, citizenship. Merely because of certain technicality, citizen should not be curtailed. That has been held in the Sarvanda Sunral second judgment in paragraph 55. Adequate care should be taken. And grandfather's name is written against the father's name in 79, 80, 85 voter list. In the same village, my lord, Khormuza. Subsequently, they have shifted, entire family shifted. And that is also in WS mentioned. Paternal uncle's name. She has three grandmother. That name has been mentioned. Paternal uncles are not mentioned in WS. Name discrepancy has been explained. This has not been considered. The explanation furnished in the WS and evidence in C has not considered by the landed court below, landed tribunal. The citizenship, my lord, should be careful, my lord. Merely on the fault of some certain technicality fault, one should be thrown out. This will be highly, my lord, illegal and a violation of human rights. That should not be allowed in our country like broad and inclusive democracy. Should be considered. My lord, it's a citizenship, my lord. It is not an criminal or other civil dispute, my lord. My lord. My lord, it is not a case that he has not at all produced those documents. The proceedee's father and grandfather are in the same voter list, maybe in different house number. And this voter list may be vernacular. It's a records, it's a documents of the government. Even this one court can call for the records and verify whether these parents and grandparents are in the voter list or not. So citizenship, my lord. My lord. My lord, I have another point, although I preferred this lordship's consideration that because of these anomalies, citizens should not go. Only the 66, the 97 and 89 voter list, grandparents and parents are in the same voter list. And my friend is arguing that the names are not in the subsequent voter. Names are there. Horizontal is in the same voter list. Diljan Nasa in the same voter list, maybe in different house, but adjacently. Family division is there. Therefore, in the 79 voter list, 85 voter list, grandfather is not with the father. Then that cannot be lawful. The 89 and 97 voter list has clearly established that although the father and grandfather are living in a separate house, but they are in the same village and in adjacent house number. That ought to be considered, ma'am. And there has been explanation in the WS. In the, my lord, notice, my lord, the notice, the charge is back. There can be two charges. Charge should be definite, one specific. Notice, lordship may kindly have page 29. There can be two charges. That means these cases are made out, they framed, without any fair investigation, without any asking any documents of the proceeding, and therefore they have made whatever they like, my lord. There can be two charts together. This is a gross mistake, and thereby the proceeding is illegal, my lord. It is not maintainable in the light of the Sonakha case, my lord. Don't push back.
Marking position. That will be correct. Ya tengo números ahí. Le voy a pegar a margen.
It is, in the notice made. This is settled, my lord. The wrong mentioning in the notice will not hurt. This is, my lord. In fact, this is 2017 4 GLR NOC 5. There is a judgment. 2017 4 GLR NOC 5.
NOC 5.
Name.
Here, my lord, it's a short judgment, my lord. Short judgment. Here it is said by applying similarity. It can also be said that the wrong mentioning of the foreigner's stream as classified under section 6 of the Citizens Act 1955 as amended to which the notice belong would not vitiate the proceeding or the consequential order passed by the tribunal. If material on record disclose that the notice actually belongs to the stream of the foreigners, which has been ultimately held to be so by the tribunal. So this will not help. Another judgment of this honorable court, it is clearly 2017 2 GLT 996 on the same line. 2017 2 GLT 996, madam. 996. 2017 2 GLT 996. Here it is Ananda Ghosh, madam. Here it is Ananda Ghosh. Yes, madam. There it was Abiran Nessa, madam. Earlier one it is Abiran Nessa.
ABRAN.
ABIRAN. Abiran Nessa. NES. Yes, any doubt. Para 12 and 13, my lord. Para 13 has clearly said, my lord, having regard to the above, we have no hesitation to hold that when the reference was as to whether petitioner was a foreigner belonged to post 25/3/1971 stream, non-mentioning of the same or wrong mentioning of the stream of the foreigner to which the petitioner belongs in the notice would not vitiate the ultimate conclusion reached by the tribunal that the petitioner was foreigner of 25/3/1971. So it would not vitiate, man. Wrong mentioning in the notice. Please, madam. NOC one, madam. Yes. Hold.
My lord, I want to revert their contention. My lord, my lord. The judgment they have, my lord, my friend has shown, my lord. Those judgments are not at par with the full bench decision. Full bench decision goes to show that notice with main grounds are to be served. Paragraph 124. Unless the non-service of the main grounds, though mandatorily required, amounts to denial of reasonable opportunity to the defendant to defend herself, thereby violating the basic principle of natural justice. So, my lord, if the notice, paragraph 124.1, if the notice, my lord, this notice is wrong, then where is the main grounds? If there is no main grounds, no case. And that is also mandatory under clause 3 of the Foreigners Tribunal Order 1964. They cannot simply say that the notice mere wrong cannot be, my lord, they cannot be, tribunal cannot debar to declare him as foreigner. The tribunal has no jurisdiction to take up the case without the main grounds. If their main grounds is wrong, then the whole proceeding is illegal, my lord. Then, my lord, I have to rely, my lord, on the Sunaka case, paragraph. Sunaka case, my lord, 250, my lord, paragraph 10, 9 and 10. 9, 10 has said that the charge should be specific. It is, my lord, the last two, 3 line has written like this, my lord. We are of the opinion that, we are of the view that the referral authority cannot make a reference merely to ascertain as to whether a person is a foreigner or not without making any specific reference of a period which has a basis in terms of the section 6 of the Citizenship Act 1955. It may also be noted that the tribunal also cannot give any opinion beyond the reference as already held by this court in the case of Santosh Das Chopra. Santosh Das has said, my lord, clearly. Santosh Das judgment is, my lord, it is reported as 2017 5 GLR 510. And Sunaka case reported, my lord, as 2021 3 GLT 12. My lord, these two decisions has consistency with the full bench decision and clause 3 of the Foreigners Tribunal Order 1964. The judgment referred, my friends, are not inconsistent with the clause 3 of the Foreigners Tribunal Order 1964 and the full bench opinion in paragraph 78. These are not acceptable judgment. Full bench 78 as well as 124.
Details on notice, my lord, your lord will find with regard to the notice in the.
My lord, if this way, my lord, goes, my lord, the anarchy will prevail, lawlessness will prevail.
We have to follow the law, my lord. We are not going beyond the law. My lord, what is this? My lord, Dukumia, one judgment of this honorable court, my lord. Series of the WPC 3805 2016, my lord. 3805 2016. WPC 3805 2016, my lord. Yes, 2016. Yes, Duku Mia, my lord, the party, Duku, Mohammed MD Duku, DUKHU. Mohammed MD Duku, DUKHU, Duku Mia. MIAH. A is. This is disposed on 8/3/2018, my lord. Yes. DUKHU, my lord. Disposed on 8/3/2018, my lord. In this case, my lord, the details with regard to the notice in the foreigner tribunal is discussed. The, my lord, the senior friends, my lord, argument that 3(1) of the order and the full bench, those has been referred, and ultimately there is a date.
My lord, basically, my lord, the full bench is to be followed.
Full bench is referred, that is clarified.
If full bench follows, my lord, there shall be grounds, proper grounds. Without proper grounds, notice cannot be.
Para 19,
My lord, when a criminal case, my lord, proceeded, my lord, a charge is framed, my lord, charge, police has framed a charge, then court has considered the charge, then my lord, trial. So unless this charge is properly framed, my lord, how the other side will get the
here only
chance of
question
defense.
is, my lord, whether it is a citizen or not. There is nothing more. Only one search, my lord. He is to prove that he is a citizen of India. That must be. There is nothing more to say.